Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, I want you to mark the day on the calendar. It was yesterday, November 24th, 2025. Something occurred that has never happened ever before in American history. What am I talking about? Your United States Department of Justice filed an amicus brief before the United States Supreme Court on behalf of lawful and responsible gun-owning Americans. That's right, an amicus brief in support of the Second Amendment. We're talking about DOJ's amicus brief in the matter of Wolford v. Lopez. It is a case that is coming up for oral arguments in January before the United States Supreme Court. We're going to share with you a little bit about the brief, but we're going to share with you a little bit more about maybe how we should be dealing with this Department of Justice. So today, let's spend a few minutes and let's talk about DOJ does this for the first time in American history. Okay, America, we are going to be talking about some big things today, and I want to start this off by saying, listen, I hope you appreciate the fact that we don't clickbait you here, we don't get into crazy hyperbole. So when we say, hey, this is a big thing, this is a momentous occasion, we actually mean it. Yes, the United States Department of Justice has filed an amicus brief on behalf of the Second Amendment and lawful and responsible gun owners in the matter of Wolford v. Lopez. That is the first time in the history of this country that the United States Department of Justice has done so. We are going to talk about the brief in parts so that you can get a flavor of where DOJ is coming from. What I also want to talk to you about is how do we deal with this DOJ? Because you're struggling with it mentally, I'm struggling with it mentally, and I want to share with you what an attorney much wiser than me shared with me earlier today because I think it may help all of us, okay? Now, I recognize that even here at Washington Gun Law, the last time we did a video about DOJ just a few days ago, it was about them doubling down on the NFA in the matter of silencer shop versus ATF. And yes, many of us, myself included, were really ticked off. And every time we're just about to throw in the towel on Attorney General Bondi, for those of you who haven't already, then something like this happens, okay? And it is, in fact, the most bipolar Department of Justice ever. Maybe we need to be a little bit bipolar about it as well. During a conference call today with an attorney much wiser than me, there was many other people on the call. We were discussing, do we need to be all in with this DOJ? Do we need to be all out? Maybe it's time to pull the ripcord. All these kinds of conversations were happening, okay? And this attorney says, well, why does it have to be such a binary decision here? You know, why is it that you either have to be all in or all out? And in fact, for many people, if you really want to have credibility about it, maybe we ought to just, call balls and strikes here and realize that this Department of Justice has done a lot of good things and has done some things that have never, ever been done before. Have they missed the strike zone on a few things? Yeah, they most certainly have. They absolutely, positively had. And maybe the healthiest way for us to deal with this is just to start calling balls and strikes and realize that we're going to be happy with some of the results and not happy with everything. But what's occurred here, we should be happy with. Now, the Department of Justice points right out that, hey, Hawaii enacted all of these crazy laws in response to what the Supreme Court ruled in Bruin. Bruin invalidated Hawaii's prior firearm licensing regime under which Hawaiians could virtually never obtain public carry licenses. Hawaii responded by loosening its licensing restrictions, yet it simultaneously enacted a new restriction that effectively nullifies those licenses and prevents public carry. They go on to then start talking about the constitutionality of this statute. Now, I want you to remember that this is language that has been used in a brief authored by the United States Department of Justice. Hawaii's restriction is blatantly unconstitutional as applied to private property open to the public. States cannot evade Bruin by banning public carry through indirect means. History establishes that firearms regulations are per se unconstitutional if they are designed to thwart the right to publicly carry arms or if they effectively negate the right. Hawaii's restrictions fail both metrics. Now, I want you to understand what the problem is with Hawaii's vampire law here, okay? In any other normal state, if private property owners want to exclude firearms from their property, all they need to do is post a no-gun sign. Once they do that, you cannot take firearms onto their property. Private property owners absolutely, positively have the right to dictate that, okay? The way it works in Hawaii, however, is you're just to presume that any place that is privately owned yet held open to the public. So that's just about anywhere you could possibly think about in Hawaii here, okay? It is automatically a no-gun zone, and only unless a property owner posts signage that directly consents to such may you actually carry firearms onto that property. Now, you can imagine, especially in a state like Hawaii, how many property owners, how many business owners actually want to put signs up that look something like this. DOJ puts it this way. Because most owners do not post signs either allowing or forbidding guns, and because it is virtually impossible to go about publicly without setting foot on private property open to the public, Hawaii's law functions as a near total ban on public carry. And you sit there and you go, now how on God's green earth did the Ninth Circuit uphold it? Well, first of all, it's the Ninth Circuit, that's true. But when it came to trying to justify this law through historical analogs, yes, the Ninth Circuit got incredibly creative. So much so, the Department of Justice takes it to task as well. The Court of Appeals invoked 6 supposed historical analogs, but 5 applied only to property closed to the public. The 6th is an 1865 Louisiana law enacted to prevent newly freed slaves from carrying arms. And then the United States Department of Justice kind of comes up with a new standard about how relevantly similar things really need to be when it comes to history here, or what we're going to call
not even Rahimi close.
Because they put it this way. Even setting aside those cross-cutting principles, Hawaii's affirmative consent rule is unconstitutional because it is a modern-day aberration and not relevantly similar to laws that our tradition is understood to permit. And again, in regards to all the faulty historical analysis that went on in the Ninth Circuit, and it was pretty atrocious, the United States Department of Justice also points out, the Court of Appeals upheld Hawaii's law on the erroneous basis that states have historically set default rules for carrying firearms on private property. But the 6 scattered laws the court cited, 4 from the 18th century, 1 from the mid-19th century, and 1 from the late 19th century, show no such thing. And then finally, the state of Hawaii has tried to uphold this law on First Amendment grounds as well. It is probably a terrible strategy because it has opened up a Pandora's box of arguments, one of which I'm going to hash out with you on another amicus brief that was also filed today on a separate video. But the United States Department of Justice also takes this opening to argue the court's First Amendment cases establish that government may not require a speaker to obtain a homeowner's affirmative consent before going door to door to communicate religious ideas, before mailing political literature, or even before mailing advertisements for contraceptives. Those decisions illustrate that while owners may exclude unwanted activities from their property, governments generally may not enact affirmative consent requirements for owners that attempt to prevent even invitees to the property from exercising constitutional rights. The Second Amendment deserves no less solicitude. Put in a nutshell, if you are a property owner in Hawaii and you have no problem with people exercising their Second Amendment rights while they're on your property, you are actually now compelled by government to engage in speech in order for them to exercise that right. They are compelling you to say something. The First Amendment guarantees you the right to say whatever you want. It also guarantees you the right to not have to say anything that you don't want to say. Okay, ultimately, America, yes. Is this Department of Justice completely bipolar? They completely are. Is your love affair and or hatred of them probably going to end up being very bipolar? Yeah, it is. And I think if you're being objective and you're calling balls and strikes, that's what we're going to get with this Department of Justice. But let's make no mistake about it. November 24th, 2025 is a huge day because, yes, the United States Department of Justice, for the first time in American history, has in fact filed an amicus brief in support of the Second Amendment and lawful and responsible gun owners nationwide before the United States Supreme Court. Okay, the case once again is Wolford v. Lopez. We're linking up their amicus brief down below so you don't have to take our word for it. You can geek out on it for yourself. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information's down in the description box. If you got an idea for a video we should do around here, cool. Click on that link right there and tell us all about it. If you want to subscribe to the monthly newsletter, the link to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.